Welcome to Cut to the Chase, where we talk about compelling legal, regulatory, and public interest information and news. Your host is Greg Goldfarb, an attorney, entrepreneur, investor, and activist.
All right, folks, it's time for our favorite podcast, Cut to the Chase, and that's what we're going to do. I'm bringing Tyler Vail from Shunnarah Vail. I'm sure I'm mispronouncing that law firm's name.
That's about all right. Got mine correct. That's good enough, Greg.
All right, from Alabama. Because Camp Lejeune, this is our Camp Lejeune update guy, and he's going to update us. There were deadlines, there's pending legislation, changing like jury trial, non-jury trial, all that kind of stuff. And so let's go. Tyler, you got the floor. Give us the update.
Whew, man, you covered a lot of topics right there. Let's start with some of the basics. The deadline for filing claims passed on August 10th. Some of the data that's come out since then suggests that the government received, a little over 550,000 claimants, which is enormous. But at the same time, when this case started back, a little over 2 years ago, they were projecting upwards of 1 million potential claimants. So is it good or is it bad? I guess time will tell, but it's certainly less than they originally thought, but it's still a massive undertaking and a massive mass tort to kind of wrap your hands around. So, and just kind of put in perspective, I think the largest mass tort had been the 3M combat arms earplug cases that wrapped up about a year or so ago, and that was around 250,000 claimants in that. So this is significantly larger, and that case obviously had a lot of issues. Continuing to deal with issues, and so if that's any indication what's going to happen here, I mean, this thing could go on for quite some time. Just managing the client base itself. So I'd say even if a settlement somehow was announced by the end of the year, which I don't foresee, but say it was, I could still see this being a 2-year plus settlement process for everyone. So everybody just needs to sit tight and let the lawyers work and just know that good things are to come.
All right. So unlike a lot of cases, this case, there's sort of a slightly different take in the sense that the defendants are not going to do knockdown, drag out fights. They've been basically encouraged by Congress to get this settled, but yet they still have to do their due diligence and set up their platform to be able to do their due diligence. And that is part of what is going to take so long, is them getting their act together, so to speak. Is that, I mean, that's kind of what I'm hearing in the background. Is that accurate to some degree?
On paper, that's exactly accurate. This was supposed to be a settlement, with the legislation being funded, and they're supposed to evaluate claims and pay claims. Unfortunately, it has turned into pretty serious litigation, unfortunately. And my position, along with the position of probably most of leadership, is that, it should be a settlement process. We're trying to get these things moving, get clients paid. This is not a young clientele that we have. In fact, many deceased clients already, but we have clients, dying just like everyone else does in this case monthly. And so what we thought was going to be a settlement process, the government has been fighting us at every turn. Every time we try to get information, it goes into just protracted discovery motions with the court. Every time we try to, do anything, move forward with the case, it seems like we're just getting hit, like we're in full defense litigation. So a little unexpected. We thought it'd move a little quicker. We thought the government would take a more just client-friendly approach. We're dealing with, military folks or their families. And so we thought that, since they're the ones responsible for causing this mess for many decades, hide it from everyone, they'd take a more casual approach and kind of defer to what Congress kind of ordered them to do, was to settle claims, not litigate claims, not fight us at every turn, and really, like counting exact days there at a base, requesting, how much leave a client took during that time period to try to knock their claim down from the number of days we're stating. I mean, it just has kind of gotten a little out of hand. So we were hoping, just last month, or I guess it was about 6 weeks ago, the court appointed, with the assistance of the government and plaintiffs' leadership, appointed 2 settlement kind of special masters to kind of settlement masters, so to speak, to kind of come in and try to get the sides together and try to get some things worked out. Obviously, like I said, it's a huge litigation. At the time they were appointed, they did not realize the total number of claims. So now that deadline is passed, maybe it's a great jumping off point. They know exactly what they're dealing with. There's never going to be additional claims in what's filed. And so hopefully some common ground can be reached fairly quickly, at least for the client's sake.
All right. And so you said 550,000 claims have been filed.
Right. Maybe 554,000, give or take.
Okay. Unlike like the 3M settlement, which was sort of an all or nothing deal, everybody got settled all at the same time, and then they're going to get paid over time. In this particular case, there have actually been some settlements so far. And how is that different? Like, some individuals have settled and gotten paid.
Correct.
Camp Lejeune. Like, how is that different than, like, let's say the 3M?
Right. And we were able to settle, not a lot, but I don't think a lot were settled. I think we ended up settling 6 of our clients. The government put forth, I think, because of the pressure they were receiving from attorneys, from Congress, just from everyone, about how slow this is moving. They put this elective option settlement option out there, probably over a year ago. Again, but they were only willing to pay a certain amount of money, max amount of dollars, and they were only going to pay on maybe 7 or 8 injuries. Our position is, one, the cases were significantly more than they wanted to pay, and the amount of injuries that we're going to be able to prove is related to all the chemical exposure at Camp Lejeune during this 30-year time frame is going to be expanded quite a bit from what they're trying to limit it to. So while we did have an obligation to our clients when they offered money to report to our clients, some of them took the money. They got as high as maybe $400,000 for a couple of our clients. Some were in $200,000 range, but again, it was only for specific, age-specific injuries, mainly cancers, and Parkinson's. And again, I think that's extremely undervalued for what these folks are dealing with or what they did deal with. Yeah. And so I would say, and I haven't seen the latest numbers, but again, at the time when there were several 100,000 claims filed, I believe the number of settled cases was somewhere around 20, maybe 30 max. I mean, it was just less than like, 0.5% or even getting offers and settling. So again, they tried, I get it, but I think it was just almost like a false attempt to try to get some Congress men and Congresswomen off their back for dragging their feet. So not a super productive campaign, but it is out there.
All right. So I don't want anybody to be confused. I know you mentioned 7 to 8 different types of injuries, mainly cancer and Parkinson's. Some people had issues with pregnancy. Some people have other issues. Just because you said 7 to 8 injuries and most of them being cancers and Parkinson's doesn't mean that that's going to be the limit. That's just what right now the government is essentially acknowledging is in play.
That's exactly right. That's what the government wants to pay on. That's not what we think we can prove or what we're pretty sure we can prove. I honestly, by the time this is done, I would think that injury list would, hit close to 20 different types of injuries should be compensated in this case. Right. That was the problem. I think the biggest problem with the elective option rollout the government tried to do was that they limited it very, just it wasn't necessary. I think they could have been a little more broad. They were just really not wanting to pay claims. And so they limited us to a small number of injuries. But right, that only makes up, maybe a third of our inventory. We represent, a little over 10,000 claimants. And if we would only, if we would just defer to the government, say, okay, y'all are right, we're only going to agree to these 8 injuries. I mean, shoot, that would take, 2/3 of our cases away. And I think our inventory is pretty lined up with the rest of the country. So it's just not going to happen. And that kind of leads to a lot of the fighting going on in the court right now.
All right. And I believe the last time we talked, I thought you mentioned that there was some scientific study going on to determine, whether certain injuries were related to this water contamination. Did I get that right?
No, that's exactly right. And it's like all environmental exposure cases, and this, but if some folks are listening who don't realize, a lot of these things can manifest over time, long time, maybe 20 years, 30 years. And so the studies are going to follow that same track. And while there are probably another dozen studies dealing with, the exposure at Camp Lejeune and the types of injuries that all these claimants may have, it's just going to take a little time. There has been a couple that have come out probably since we spoke, and again, what they did was they expanded the number of injuries that they're relating to it, and these were government-sponsored studies. So again, the elective option did not even recognize this new study that the government kind of put in place and conducted. They stuck with their, hey, we're only paying these 8, regardless of what this new science says, and that's just going to be a line that they're going to draw that in, draw a line and say, hey, we're not moving from this. It's just going to drag these cases out, which is not what anyone wants, not what Congress wants, certainly not what these claimants want or deserve.
All right. And I believe the last time we talked, one of the battles that was going on with the government was getting certain documentation. And I believe one of the groups of documents that you guys are trying to get would show where these individuals, when they were actually at Camp Lejeune. So the government basically knows they have documents, they don't want to produce them. Is that, did I get that right? And is there an update on that?
Yeah, it's a little everything. It's a little everything. What we're finding, that is the most difficult thing for us to gather from our clients right now. And, we're constantly asking them to take it upon themselves to help us out, because a lot of these are, 40, 50 years old records we're trying to locate. And while the government, and leadership, they have tried to put together a database that takes into many different administrative agencies, maybe even, tax records, everything, employment records, trying to create a big database where people can go and run their clients through and see what type of proof they can find. Man, it's just got so many holes. It's just almost impossible, so we're taking it upon ourselves, ordering, records individually for clients through different government agencies, through military agencies, also requesting clients to get it. But what we're finding, and this won't be news to a lot of people, is that, the say the warehouses where all these records were stored all these years had a massive fire back in 1973. And with that, I mean, hundreds of thousands of military records were all destroyed. And so a lot of our requests, the response we're getting back from the government was that, unfortunately, these records were destroyed in the fire, in 1973. So how do we overcome that as lawyers? How do we overcome that, and convince the judge and convince the government otherwise? We're working through that. I think it can certainly be done. Client testimony, obviously, if it gets that far in the court or in depositions, can certainly testify to where they were. There's nothing wrong with that. And so we're having to kind of, it's just evolving. It's an evolving issue. It's certainly a problem. We're using everything from old yearbooks. We've hired a bunch of different experts who go out, who are kind of deal with, family archives and family trees and grabbing data for us and going back through telephone books from the 50s through the 80s, yearbooks in North Carolina around, Jacksonville, getting around Camp Lejeune, all the schools, looking for children's pictures in the yearbooks, just any type of proof we can get. We have pictures of service members with friends there at Camp Lejeune, maybe a graduation ceremony picture or a certificate that shows they graduated. I mean, we're trying to piece it together, and it is by far the most difficult puzzle of the whole case.
All right. And when this whole Camp Lejeune litigation came about, it came about as a byproduct of legislation. And there was certainly the issue of whether you're entitled to a jury trial, and the judge ruled no jury trials here. Where are we at with that now? And I heard that there was legislation to clear that up. So you tell me.
I'll tell you, I have seen several. You're correct about the jury trials and the judge issuing that order. My understanding, I'm 90% certain of this, the order from the judge was appealed to the Court of Appeals. We're trying to get a different ruling from an appellate court, But also in the meantime, there's also legislation trying to get pushed through. Nothing has happened yet on the legislative side, but I have seen many different proposals coming from many different congressmen and women that are trying to do different things in Camp Lejeune. And I'm not sure how it's all going to pan out. Nothing, like I said, nothing new has passed on it. But there are lots of proposals to kind of, one, help this case wind up, help get it away almost from the government, to help get it to special masters, get it special administrators. They can work a settlement process a lot faster than the government can. I've seen some proposals dealing with allowing jury trials. So it's lots still happening. Nothing officially passed yet, but certainly that ruling kind of took some folks by surprise, and whether it stands, time will tell.
All right, and for us lawyers out there, are the attorney's fees part of the legislative proposals that you're seeing?
Yes, I've seen some attorney fee caps in some of the proposals I have. Again, nothing's passed, and I think attorneys fee caps in legislation, in proposals, started. This thing was signed August 2022, and I believe the first fee cap proposals being issued through Congress and were in October of 2022. So just within a couple months, and I've probably seen a dozen additional ones. So we're not sure where it's going to end up. Right now, the government has set fee caps on the elective option. If the clients choose, if the government makes an offer based on what they're seeing in their documents and want to kind of have them participate in the elective option, they put a fee cap of 20%. If it's filed in North Carolina federal court, they allow the attorney to get 25%. Again, that's just from the government's perspective on the elective option. It hasn't been a blanket, this is how it's going to be for all cases. Obviously, that's something that is likely to come up if settlement discussions continue. But yeah, the proposals on all types of things, Greg.
All right, last topic. I read that the judge wanted both sides to start agreeing on certain things, and it appeared from what I read that was not the judge was not successful. What happened there? What was the judge trying to get everybody to agree on?
Well, it's all about us trying to get more information from the government. I can't even guess the number of different agencies that have some type of related information that we think is related to this case. I think we've put out, maybe 6 to 7 different sets of requests for production, because every time we get new documents, you learn of another agency or another department that may have relevant documentation. And so it leads to more requests, and we're going. The government is basically throwing up their hands and saying, look, man, we've responded to, 6 of these requests. We're not going to continue to do this. And the plaintiff's like, hey, man, we have to continue to do this. There's no other way around it. We got to get this information. We're allowed to prove our case. And so the government, again, we're fighting at every turn instead of trying to work through negotiation and trying to make this a settlement, which was what it was intended to be when it was passed, a couple years ago. They're fighting this at every turn. And just recently, I believe the judge issued an order that did limit our request, kind of sided with the government on that last request we made, that basically said that, I'm not going to allow that 7th request for production to proceed, at least not at this time.
Okay.
So yeah, discovery stuff, we're just trying to get as much information as we can. They're dragging their feet. They're making it hard on us. Again, it's just seems like it's turned into every other case we work on.
All right, and as promised, there is going to be one more question. Are there any cases set for trial? And if so, what time frame?
Yes, I believe they're tier 1, track 1 cases are set for trial. Man, I want to say early 2025. I want to say March, April. And you kind of caught me off guard. I have that just not right in front of me. But yeah, there are some cases set. Again, they've selected some pretty good injuries, some pretty hard cancers and Parkinson's for the first wave of cases to go through. And hopefully that'll help establish some values, which, again, these 2 settlement masters that were appointed can hopefully use this information to try to get all the sides together and get something done for these folks, man. It's been a long time coming.
All right, well, that'll do it for this episode of Cut to the Chase with Tyler Vail, talking about Camp Lejeune. We're going to get more updates. Maybe in 3 months from now, you'll have another opportunity to get us up to speed and answer questions. So anybody out there that has questions, put it in, go to my YouTube channel for this particular video, put the questions in there. And when we talk with Tyler again in 3 months, I'll get those questions to him. But number one takeaway, no more cases. If you haven't hired a lawyer by now and you haven't filed your claim, you're SOL, statute of limitations, goodbye. Number two, some of them are settling, but we're going to have to prove our cases, and we're fighting just like we fight on all other cases, and we'll see where this goes. Thank you for coming on today. Tyler, you got a lot of work to do, all right?
Greg, thanks so much. Absolutely, man. We'll talk soon.
Okay, my man. Be well.
That's all for this episode of Cut to the Chase. But before you go, will you open up your podcast app and give us a 5-star review? You can also leave a comment about what you liked most or other topics you'd like us to cover. And please be sure to subscribe so you don't miss any upcoming shows. Thanks, everybody. Be safe out there.